Hi guys, welcome back to Battle with Ola. This is Mujola Oluwa, and today we want to talk about confessions in criminal law. Confessions in criminal law. Confessions are statements, or a confession is a statement of admission of guilt, in the instance where a crime has been committed. Let me read what the Evidence Act says. Section 28 of the Evidence Act defines a confession as an admission made at any time by a person charged with a crime, stating or suggesting the inference that he committed the crime. So that's a confession. You are saying that you committed a crime, or you are confessing to having partaken in the commission of a crime. So that is what a confession is. It's very crucial. Usually it's made to the police or to the arresting authority or to the investigating authority, who would usually take it down or put it in writing, and then it is tendered in court as evidence against the defendant who has made such confession. Let me read section 29 also. 29 talks about the voluntariness. It says that a confession must be voluntary and obtained without oppression to be relevant and to be admissible. It must be. In the next video on criminal litigation, we'll talk about relevance and admissibility. Those are also two important things in criminal law, criminal litigation. But 29 here is saying that a confession must, be voluntary and obtained without oppression for it to be relevant and to be admissible. That would mean that the person must have volunteered, must have, made the confession on their own. So much, it mustn't be under pressure. It mustn't be that maybe the police or AFCC or NDLEA or DSS or whoever is getting the confession. It mustn't be that they have extracted the confession by force, by duress. In some instances, the law enforcement agents, they beat up the victim. When I say victim now, I'm talking about the defendant, which they are victim. When they beat them up, they batter them, cudgel them, and all of that. They beat them up just to have them confess to a certain crime. In that instance, if the court can prove, or if it can be proven to the court that is how the confessional statement was obtained, it will be inadmissible. So 29 here says that a confession must be voluntary and obtained without oppression for it to be relevant and for it to be admissible. In Olabode and the state, the court held that a confession must be voluntary and it suffices without corroboration. Once it is voluntary, it can be tendered to prove a crime without the need for corroboration to suffice as a ground for conviction. Now, the confession of a co-defendant, where there are more than one defendant in a crime or in a matter, the confession of the co-defendant does not, bind the other defendant except they admit it by conduct or in words. So if they do not admit it as such, it does not bind them, each confession for each defendant. Now, when the confession is made, the police or any other law enforcement agent will take it down. Then we have what we call a confessional statement. So that's the confessional statement that is filed alongside other documents and sent to the Department of Public Prosecutions as proof of the case file. So the confessional statement is usually filed alongside other documents in the investigation, and that's what we call the case file. So a confessional statement will be part of the case file. Now, just to prevent the absurd practice of some law enforcement agencies to obtain confessional statements out of their victims who are defendants in court, by hook and crook, the law has evolved such that there are now provisions in the administration of criminal justice laws of different states setting out guidelines for obtaining or for recording a confessional statement, because there's a problem with the word obtaining too. The court has held in some instances that using the word obtain signifies duress and signifies compulsion, forcing the confessional statement out, obtaining it. So it's not a proper word, should not be used. So the word is maybe recording the confessional statement or taking down the confessional statement, from the defendant. So some provisions that have been made are that if you check section 9 of the Administration of Criminal Justice Law of Lagos State, it says that the confession must be recorded. It must be video recorded. Let me read that provision to you. It says that Section 9.3 of the Administration of Criminal Justice Law of Lagos says that a confession must be video recorded or taken in the presence of the accused person's legal practitioner, evidenced by his endorsement on the statement, or it is vitiated. That's a clear provision. It says that the confessional statement must be videoed. When the accused person or defendant is making the confessional statement, oh, I went to so place, I did this, I did that, the police must record it, video recording, or the person's lawyer must be present. Ordinarily, when a person is arrested by the police and is going to be interrogated, it's important for their lawyer to be present so that they do not witness against themselves or say things against themselves, and so that the police do not unnecessarily incriminate them or any other law enforcement agent. The law now is even stating that record it on video recording, or have the person's lawyer present, and that lawyer must sign that confessional statement saying that they were there when it was made, just to eliminate the possibility of duress and force, and obtaining of the confessional statement. Because if the matter goes to court and the defendant can prove to the court through their lawyer that the confessional statement was not made voluntary, that they did not volunteer that story to the law enforcement agent, it will be inadmissible, and it could be very fatal to the case of the prosecution. So this is why it's important for this provision to be followed. Several other laws, Administration of Criminal Justice laws of different states, also have similar provision. If you check that I checked that of Ogun State, and I saw that even though it has the provision, it's a conditional provision. It's not absolute. So it says that they may, record it. So we all know that the police or any law enforcement agent might just choose not to record it, especially if they intend to obtain it by force or under duress. So such laws need to be amended so that the law can be clear. It could become a mandatory provision. Record it or have the lawyer there. I handled one matter one time when I was a prosecutor with the state, and in the file I saw that a lawyer, the defendants did not even have a lawyer, but they got a counsel from legal aid who then signed and attested to the fact that she was present when their statements were obtained. And then the case file came with video CDs. It was a DSS matter, so it came with video CDs, recordings of the defendants when they were being interrogated by the DSS officers. They were being recorded, so we could see how the statements that we were going to use in the case, how it was obtained, and the court could also see, because we tendered it as part of our evidence in the matter. So it's important that this provision be made mandatory, because so many people have gone to court and probably gone to jail because of a confessional statement that they did not make, but that the law enforcement decided to manipulate, and make for them or force out of them. Sometimes they even force, reportedly or allegedly, now they force people to say things that incriminate themselves because they are under duress. When I was a private counsel, I had handled one matter whereby, our client had told us that, he was asthmatic, and then where our client, was asthmatic, and then he was arrested, and under duress, he made a statement, promising to refund and return what he did not steal or take, because he was afraid that if they did not release him on time and he had an asthma attack, in custody, he could lose his life. So he was afraid. Some people are more afraid than other people. But essentially, the provisions of law is to eschew, violence and forced confessions. If a lawyer is saying that or if a defendant is saying that the confessional statement was not made voluntarily in court. Ordinarily, what happens is a trial within trial. I've done a video on what a trial within trial is in Nigeria and how it goes. It is essentially a mini trial within an ongoing trial to determine the voluntariness of a confessional statement. But courts are now moving away from that, and that's why some of these provisions are now in the new laws to say that record it when you're making when this person is making their statement to you, or have their lawyer present, so that when that lawyer is coming to court, the same lawyer will not come and say that the confessional statement is not voluntary, because they were there when it was made. So these are some of the innovations to preserve, the integrity of a confessional statement. So if a confessional statement is not contradicted or controverted in court, it suffices to convict a defendant for a crime without corroboration. So that's the position of the law on confessional statements. We saw that in Olabode and the state, and that's how the court has decided in several other cases. Also, confessions are usually extrajudicial when they are made to the law enforcement before the matter comes to court. But when they are made in court, that is when the accused person volunteers the statement or the confession in court and says, oh, I did this, oh, I did that, before the judge, we say it's a judicial confession. Where made outside of court, it's an extrajudicial confession. The fact that a defendant resciles from their confessional statement or retracts their confessional statement does not make it automatically inadmissible. The court will admit it, but then it could affect the weight that the court will attach to such statement. So if somebody resciles from their confessional statement and says that they are no longer saying that, not that it was obtained under duress or anything, but they are saying, oh, I'm not saying that again, or I was not even the one that made this statement, the court will still admit it, but now could attach little weight to it, or less weight than it would have attached if the defendant stuck to the confessional statement. It's important to note that the most important consideration for the admissibility of a confessional statement is the voluntariness. Was it volunteered by the defendant? If yes, the court will go on and rely on it, and without needing corroboration. But if there's no corroboration, there are other things that the court will consider before relying or basing the conviction on the confessional statement. Those things are that, one, other things that have come out, facts that have emerged, and other admissions and answers that the defendant, for instance, has provided during the trial agree with the confessional statement. Then that it's plausible, there's a possibility that the accused person or the defendant could have committed the crime. That is, they had the opportunity to commit the crime, the proximity and all that to commit the crime, and there's no controversy from their own part or from any other part, from all the parties to the trial. No one has controverted the confessional statement. The court will most likely rely on it. So aside the fact that it must have been voluntarily made. Now, there are some rules of practice, not rules of law, but rules of practice that guide confessional statements. And those are, it's called the judge's rule. The judge's rule implores the police officer or the investigating officer of any law enforcement agency that will take a confessional statement to caution the defendant or the accused person or the suspect at this stage before obtaining the confessional statement. Tell them that they need not say anything, but if they have anything to say regarding their arrest and why they have been arrested, they can do so, and that will be taken down in evidence and used against them. So they are required to caution them and then put down whatever they have said. And if the defendants or the suspect can write for themselves, they can write, but they must write some words and sign that they understand that they do not have to volunteer a statement, but they wish to say this and that, and they have said it voluntarily, and they know that it can be used against them in the court of law, they sign something of the sort, and then they give their confessional statement. And usually too, where an officer has signed a confessional, taken down a confessional statement, is to take the defendant to a superior officer, who would then also sign the statement that the statement was taken voluntarily, and they have read through it, and the defendant or the suspect has nothing against the statement, that the suspect volunteered the statement. So different rules, all to ensure the integrity of the confessional statement. So you see that it's a very important piece it's a very important document in criminal litigation or criminal trial, because it also forms a permanent document of the defendant's account or the suspect's account of whatever the matter is about, or whatever crime has been committed. So it's very important. A confessional statement is very, very important. What if the suspect does not understand the language? There's a provision that an interpreter be provided, who would listen to them and take down what they have said. And such an interpreter is to be called in evidence, to tell the court that they actually interpreted, the confessional statement to the suspect after they are taking it down, and that the suspect understood what was taken down and agreed that that is what they wanted to put forward. So there are different guidelines just to ensure the integrity of the confessional statement, and more so the recording and the presence of a lawyer now, just to eliminate the need for trial within trial. I've said it in this channel before that I worked on a case wherein the case was paused for about 2 years, just so to deliver the judgment, the ruling in a trial within trial. So by the time parties went on trial within trial, one of the accused persons had jumped bail. It was a murder matter, so it was serious. So the court continued to adjourn and adjourn to enable the appropriate parties facilitate the presence of the defendant in court, but eventually they had to strike out the name of the defendant. We had to strike out the name so that the judge could deliver the ruling in trial within trial, and the trial could continue. Striking out until such a person is rearrested, of course, not that they are free forever. So this is one of the reasons why the court now is moving away from trial within trials. There are some practice directions that have even outlawed trial within trial in some jurisdictions in Nigeria. What does a confessional statement look like? As a prosecutor, I'm in a very good position to tell you this, because I've read so many confessional statements in this life. So many. Confessional statement is like you writing the story of your life in Nigeria, all that I've read. Usually, you state your name, your age. The police already have papers that are designed for this, so there are columns for your name, your age, your occupation, where you live, where you're from, your nationality, what you do for a living, and all of that. I think your religion too. And then you will now start telling your story, how you're connected or disconnected from the crime for which you're being accused or arrested. So you tell all that. Now, what you find in some confessional statement is very funny. There was a confessional statement I read one day. It was about 6 pages, and you would just know that no accused person will volunteer this manner of confessional statement. There's some manipulation ongoing with the police. And in the confessional statement, the accused person told us the story of his life from when he was born, the primary school he went to, how he dropped out of school, how he started stealing cars. He joined a band, they started stealing cars, and then he went on and on. I think he said he went to prison, came out again, found his band, and then they told him to come to another city for a robbery. They went to rob together. It was a long story, but you would just ask yourself, what kind of suspect would ever volunteer this kind of story? Now, you've been arrested for a crime. What is the possibility in the world that you will tell your story such that you will implicate yourself for other crimes that you earlier committed? So there are so many manipulations that go on with confessional statements, that makes it impossible sometimes for a defense counsel to just let it slide. So they would normally just contest it, because it's an important document and their client could go to jail if not properly contested. So it would usually contain the details of the crime and how the person giving it is connected to the crime, what they did, their own role, and all of that. So that's what is contained in a confessional statement. And of course, the volunteer, that's the suspect, will sign, and then the police officer would also sign. They'll take it to a superior officer who would also sign. But if these signatures are not there, that is that of a superior officer, or the person was not cautioned, some of these things, they're just administrative provisions. They do not go to the root of the confessional statement, so they will not vitiate the statement. Things that can vitiate it is if you're prosecuting a state where it has been mandated that it must be recorded and it was not recorded, or a lawyer must be present and the lawyer was not present. That's what could vitiate it. Or if the accused person is even saying that I did not give that statement, that's not my statement, I never confessed such. So those are some things that can vitiate a confessional statement. But if not controverted, if not reserved from, if not retracted, if not described, or if there's no allegation of involuntariness, and other facts surrounding the case coheres with the confessional statement, the court can convict an accused person or defendant on the basis of the confessional statement. So that is what a confession is, an admission of crime, just to facilitate the conviction. I hope you learned a thing or two. If you have questions, leave them in the comment section. I hope I covered all grounds. I will see you in my very next video. Don't forget to subscribe and bring a friend over to battle with all our to-dos.